All right, you guys, I couldn't get it to go back to the very first screen, but the first screen says legal and ethical issues. Okay, so no one freak out. That's what we're talking about. Here's the unit outcomes, and I'm just going to keep talking until I finish everything, so I don't know how many of these there'll be, but they'll all be posted. Okay, the State Nurse Practice Act is the most important piece of legislation. It defines our legal bounds. So it defines the scope and standard of our practice. It defines the function of each nurse, the registered nurse, the LVN, you'll see that mostly down south. We don't see those up here. And the LPN and the advanced practice nurse. It sets the educational examination requirements. All right, you might keep hearing a clicking. That's my heater. It's really super old in my office, and so it's noisy. The State Board of Nursing is the regulating body. They enforce that the Nurse Practice Act is being done, I guess, for lack of a better word. Another thing to remember about the Practice Act is that there can't be any exceptions. They can't waive any provisions or expand the act. The whole act needs to be opened, which is why it doesn't ever happen, because people get nervous that lobbyists are going to come in and change things we really don't want to see changed. But the Board of Nursing enforces the Nurse Practice Act, and their job is to protect the public. So the last time we were together and we talked about Julie Towle, what we looked at was what the Board of Nursing decided for her. Okay, the National Council of State Boards of Nursing, they are the ones that record and enforce all the actions against an RN. And then you can see them in their, like Julie Towle, I just put in her name in a search and that all came up and you could read it. We read it right off the website. This is the Multi-State Nurse Licensure Compact. You can click on this and go to the link and watch that video. There's nothing on the exam about that, but if you live in a different state, this is a site you might want to go to help you. If you have any specific questions about what you should or shouldn't do, I can help you answer those, okay? But I'm not going to go to it now. It is your responsibility to keep up with any changes in the Nurse Practice Act. And if you move to another state, it's your responsibility to know what you can and can't do in that state. However, know if the Nurse Practice Act was going to be reopened, it would be a huge deal. You'd be hearing about it. It's not like you got to check every week or anything, but it is your responsibility. Okay, now we're going to move into different legal terms. Okay, negligence is a conduct that is lacking in care. This is a non-professional, mostly unlicensed person, and it deviates from the standard of care that a reasonable person would do. Okay, so like in my example where I had the CNA that didn't recheck the man who was getting blood, that was an example of negligence. Malpractice, you'll also hear malpractice called professional negligence. Okay, and this is a professional person, someone who is licensed. So as nurses, we would be sued under malpractice or professional negligence. Failure of a person with a professional education and skills to act in a reasonable and prudent manner. Reasonable and prudent means exercising average care, skill, and judgment in conduct that society requires of its members. It's not above average. Reasonable and prudent is average. Okay? In the case of Julie Towle, it came down to not putting on her identification band and not scanning the meds. Reasonable and prudent. That is what an average person would have done. Elements of liability or elements of malpractice. These are the 6 elements. All 6 must be proven in order to prove malpractice. Okay, and I'm going to give you an example of each. The first one is duty, and duty is failure to monitor a patient's response to treatment. That is an example of duty. Okay, so if you give somebody a new medication, a pain med, failure to monitor a patient's response. So in the case when we were talking last week about Sister Maria and the traveler nurse, they clearly weren't monitoring her response to the pain meds, right? So that was a breach. That was a malpractice of duty. And then there's breach of duty. So failure to meet the standard of care based on what a reasonable and prudent action of a nurse in that role. So a breach of duty would be failure to communicate a change in the patient's status to the primary care physician. So when we think about Sister Maria and traveler nurse Sue, remember I made up that name, not only did they have fail in their duty owed to the patient by not monitoring their response, that lack of monitoring led to a breach of duty owed to the patient, right? Because they just kept giving her more and more drugs all night long. Foreseeability of harm. This is failure to ensure minimal standards are met. That you, by not meeting the minimal standard, this could cause harm to the patient. There has to, like not putting the name band on. Nurse must have prior knowledge that failure to meet the standard of care could cause harm. Not scanning the med. All right. Causation. There must be a direct relationship between what the nurse does and the harm to the patient. If you can't prove that that relationship exists, you can't sue for malpractice. So there has to be a direct relationship. Giving Miss A the epidural in her veins. That was a direct relationship between what Julie Tao did and what happened to Miss A. Injury. It has to be physical. It can't just be psychological or transient. It has to be physical. This could mean something as easy as grandma's in the hospital for a UTI and she falls trying to get up by herself and breaks her hip. That could be injury. But remember, all of these things all of those elements have to be proven in order for you to be awarded damages. In addition to money that people can get because something bad happened to them that was non-intentional, they can also make people pay for hospitalization and future medical care. Liability is another legal term, and personal liability is just as the name indicates, that the person is responsible and accountable for their own acts or omissions. Vicarious liability is this would be the liability that the employer was responsible for. That's why when you see lawsuits, you see that they sue everybody. That's why. Because even if this person isn't liable, then maybe their employer would be liable. However, this idea of indemnification, this allows your employer to turn around and sue you. If you were negligent in something and they ended up paying and not you, they could turn around and sue you for the money. Okay? Corporate liability is if they're negligent in their hire or firing, if that results in patient injury, or if they fail to hire qualified, competent, and adequate staffing, that would fall on the RN manager. Their responsibility is maintaining an environment that ensures quality. So if any of the reasons for the lack of that has to do with hiring or firing, patient injury, or the person was not competent, that's called corporate liability. They're liable for that. All right, so we'll go into reasons that a nurse manager can be sued. So if they're not supervising right, okay, because it's an active process, if they delegate incorrectly, if inappropriate assignments are made, all of those reasons your nurse manager can be fired. Okay, that's not right. It's early. For all of those reasons, your nurse manager can be named in a lawsuit. Now know this, if you are a nurse manager and something happens on your unit and there's a lawsuit, you will be named, period. Even if none of these things occur, you will be named. You'll be the one in the deposition sitting in the chair. That's just part of the job. Okay, the other is if you didn't orient, educate, and evaluate the nurse who makes the mistake. That's why they make you do corporate compliance. That's why they make you have, that's why you have performance reviews every year to evaluate. And that's why they spend so much money on orientation. And we also have this failure to warn. So if you have an employee that has an addiction issue, violent behavior, or they're incompetent, and you don't warn the next employer, you could get in trouble. Now, there's some things that you can't tell other employers, but these are the three things you can, and it's because of qualified privilege. Sorry, it allows people to, hang on, let me look. Okay. It allows people in management positions to talk to one another on a need-to-know basis. Some other reasons would be for staffing, not having the adequate numbers of RNs to LPNs, float, if you do an unsafe float, or use of temporary agencies. All right. Remember, agency staff are looked at as independent contractors. This idea of a parent agency doctrine, I'm going to pause this. Okay, I'm going to move on. This apparent agency doctrine, the principal becomes accountable for the actions of the agent. Oops, if they're unable to differentiate from core staff. And that means, like, when I was on the floor, we had agency travelers with us that had been with us for years at the end. I think some of them were with us for 2 years. You couldn't say that they weren't core staff anymore, that they were agency. They were there so often and so much that they kind of became acclimated and looked like they were part of our staff. Okay, I still have time on this one, so I'm going to do this about protective and reporting laws. As a nurse, there are 5 reportable sexually transmitted infections that you have to report. Here are listed 6. I don't know why. It's Michelle's slide. I keep forgetting to fix it. All right, so you got to report, I think cancroid to me is like syphilis. So, but you have to report chlamydia, gonorrhea, pelvic inflammatory disease, and HIV. You also have to report elder abuse and child abuse. Okay, and I think for this particular one, I'm going to stop here, and then I'll create another one for the next section. All right, I hope you guys like this.